A very good evening to all of you, friends. A very good evening to all of you. Welcome to BYJU'S exam prep. In this session, I shall be talking to you and discussing with you some very important legal maxim along with illustrations. So this session will be absolutely important for each and every one of you preparing for CLAT 2024 as well as for CLAT 2025. So people who are preparing for CLAT 2024, you guys have less than around 6 months for your preparation. And those who are preparing for CLAT 2025, you guys have around 1.5 years for your preparation. Prepare fast. Prepare in the best way possible so that you can achieve a seat in the top law schools of the country. With that, let's begin. So today I'm going to talk to you and discuss with you about legal maxim. These are those important legal maxim that enumerates a principle of law. These terms are mostly Latin in nature, so these are all Latin terms. But these terms do mean a particular principle of law. So when you are preparing for your CLAT and other law entrance examination, in those passage-based questions, in those passages, you might come across with these kind of important legal maxim. Without understanding the legal maxim, it will not be possible for you to understand the passage, and henceforth this particular session is of great importance to you. Before I begin, BYJU'S exam prep brings to you is CLAT with BYJU'S exam prep. Unlock your 3-day free trial access. Go to the description box below, click on the link, and you can access to our courses for 3 days free of cost. BYJU'S exam prep brings to you a surprise, a 6-hour non-stop marathon coming soon. So guys, stay tuned. It will be conducted in our YouTube channel, guys. So do not miss this 6-hour non-stop marathon, which is coming soon exclusively on our YouTube channel for CLAT 2024. In this marathon, we will have Abhimanyu sir, Nivedita ma'am, Alpa ma'am, Krishnendu sir, as well as Ankur sir taking these sessions. Okay, it will be a 6-hour non-stop marathon coming soon for CLAT 2024. Do not miss it. BYJU'S exam prep also brings to you get up to 90% scholarship on our preparation program. Okay, this will be conducted, this scholarship test will be conducted on 23rd of July. So be prepared, get up to 90% scholarship on our preparation program by virtue of this scholarship test. So guys, let's begin. What are we going to talk about today? We are going to talk about important legal maxim. The first one is actio personalis, mortio cum persona. It means a legal right dies with the person. Now suppose there is a case between Mr. A and Mr. B. And just imagine during the pendency of the case, when the case is yet to be decided by the court, one of the parties dies. If one of the parties die, what happens to the case? Now, the case gets extinguished into thin air. That is what we call in law. The case gets extinguished in thin air. Why? Because the law says that if I have filed a case, suppose I have filed a case against Mr. A, and if one of the parties die during the pendency of the case, then the case is extinguished into the thin air. That is what this particular maxim talks about. Now I'll give you an example. 𝗟𝗄, it's very, very important. 𝗟𝗄 is a public figure and a newspaper publishes a defamatory article about 𝗟𝗄, defaming her reputation. 𝗟𝗄 decides to file a defamation suit against the newspaper company. However, before the case reaches a resolution, 𝗟𝗄 passes away. In this scenario, the defamation claim would also not survive because 𝗟𝗄 dies. Her rights to bring the defamation suit was personal to her. Because she died, the claim that she wanted from the other side also gets extinguished. Okay, so that is the meaning of the legal or the Latin maxim called Actio personalis mortio cum persona. Am I clear? I hope I have made myself clear abundantly to all of you. The next one is called 𝗟𝗲𝗴𝗹 𝗥𝗲𝗴𝗏. Now, 𝗟𝗲𝗴𝗃, it means that, when a judge is deciding a case, let's take for example, when a judge is deciding a case, it is the duty of the judge to give fair hearing to both the sides. It is the duty of the judge to listen to both the sides before he can come to a particular conclusion. That is what we understand by the term 𝗟𝗲𝗴𝗃. It means no one shall be condemned unheard. Now, suppose there is a dispute between Neha and her employer. Now, Neha is working with XYZ company, and there is a dispute between Neha and the company. The company accuses Neha of violating company policy, leading to her termination. Before the final decision on Neha on her employment status, under this principle, the company must give Neha an opportunity to defend herself, to respond to those allegations that have been made against Neha. Have I made myself clear? So here we come with a particular maxim which is said that a judge has to, before he comes to a conclusion, before he is giving a judgment, he must give opportunity to both the sides to present their case. Right? Moving on. Next one. Volenti non fit injuria. Volenti non fit injuria. It simply means damage suffered by consent. You do not have a cause of action. I'll give you a simple example straight away. Now, suppose I and a couple of my friends decide to play football. Okay. We decide to play football. And, in a game of football, people might push, people might pull each other. Okay. People can dribble each other. Right. So, I am aware that in a football match, somebody can push me from behind. Now, during the play, if somebody pushes me from behind and I fall, and some blood comes out from my hand or my body, can I claim compensation? The answer is simple no. I cannot claim compensation because before entering the football ground, I knew the risk involved. I knew the potential harm that can be caused to me. I acknowledge the risk and I take full responsibility of the harm that can be caused during that match. Right? Let's see the illustration. There is a sign at the entrance of a go-kart racing track that clearly says risk involved, including the potential of accidents and injuries. Participants are required to sign a waiver before riding the go-karts. acknowledging the risk and accepting full responsibility. Now, if tomorrow somebody while go-karting suffers some harm or some injuries, can he or she claim compensation? The answer under the principle of voluntary non-fit injuria is no. You cannot claim compensation. Is that clear? Have I made myself clear to each and every one of you? So guys, if you are watching me live, do press the like button and share this session with your friends. Do share this session with your friends. Okay? Okay, these are very, very helpful in solving the passages that you will get in your examination. Okay, yes, no, this class is not recorded. Okay, yeah, you can make notes of these classes, but these classes will all be recorded and you can watch these classes live again and again and again. Okay, yeah. Okay, Garima. Okay. Chalo. Let's move on. The next one is, okay, so you have the entire passage. Ankush decides to participate in go-karting racing. There's a warning signal and he signs that waiver document. Subsequently, he is injured and since there's an accident, since he is willingly accepted and he knew the risk of go-karting, he cannot have a legal claim. He does not have any kind of a legal claim against those injuries that he or she has suffered. Okay, that's very, very important. Okay, is that clear, all of you? Okay, fantastic. So this is very, very important because this is a particular maxim that deals with law of torts. It is one of the defenses in law of torts. Remember that when you are taking down the notes, just write law of torts, voluntary non-fit injuria is a defense. Okay, moving on. Moving on to the next important maxim. It's called 𝗟𝗂𝗎 𝗟𝗲𝗴𝗹. Now, this is a principle that gave birth to law of torts. 𝗟𝗂𝗎 𝗟𝗲𝗴𝗹 simply refers to the fact that the law provides a remedy wherever there is a legal harm committed. Now, suppose a person's legal right is violated. The law will provide and definitely will provide for a remedy. Might be in the form of compensation. Right? In law of torts, what we understand is it is in the form of a compensation. Now, 𝗟𝗂𝗎 𝗟𝗲𝗴𝗹 is a very important legal maxim which simply says that wherever there is a right and that right is violated, suppose I have a right and my right is violated, I can go to the court, approach the court, and the court is going to give a remedy for the wrong that is committed. Let's look at the illustration. Abhishek is a tenant renting an apartment from a landlord. He has a contractual right to occupy the apartment and enjoy its amenities in exchange of paying the rent. So suppose I stay on rent in my landlord's house. I am paying rent. I have a right over this property for the time I am paying rent. Now one day the landlord locks him and without any justification, without any notice. Now suppose I am staying in my flat which belongs to my landlord. One day the landlord comes and locks me from outside. I have a right, legal right to use that land because I am paying rent. So I can tomorrow go to the court and claim compensation. I can tomorrow go to the court and claim compensation. Am I clear? Am I clear? Okay. Is that clear? Everyone. Okay. Any doubts? Any doubts? Okay. Okay. Fantastic. No doubts. Okay. Let me just check. Okay. No. Okay. Let's move ahead then. So in this scenario, under the principle of 𝗟𝗵𝗪 𝗟𝗵𝗴𝗹, since I have a legal right to occupy the apartment as a tenant, he also has a right. I also have a remedy from the landlord's wrongful action. I can go to the court and claim compensation. I can tell the judge that I pay rent, I am using the property. The landlord does not have a right to come and lock his room from outside. Am I clear? Every one of you. Every one of you. Okay. Great. Okay. Fantastic. Fantastic. Let's move ahead. The next one is Salus Populi Suprema Lex. Now, this is a very important maxim when we are thinking about law-making power of the parliament is concerned. Now, the welfare of the people is to be kept always in mind when the legislature is making a law. So, when the legislature is making a law, now, yes, the legislature is empowered under the Indian Constitution to make laws. So when the legislature, जब पार्लियामेंट कानून बनाता है, उनका दिमाग में सबसे पहले क्या चीज आना चाहिए? Welfare of the people. Welfare of the people. Now, imagine a country facing a serious public health crisis like COVID-19. And because of this contagious disease, because of this highly contagious disease, as a response, the government decides to lock down. You know, we all have experienced those strict lockdowns around 3 years back. Enforcing lockdowns, enforcing social distancing rule, and mandate that use of mask in public spaces. So, welfare of the people has to be kept in mind at all times. Am I clear, everyone? Welfare of the people. Okay. Sir, in this legal maxim, only the law of torts. See, yes, 𝗟𝗵𝗪 𝗟𝗵𝗴𝗹 is the maxim that created law of torts, but that can also be used in law of contracts. Suppose your contracts have been violated, your terms and condition of a contract has been violated by one party. Of course, there is a remedy. In criminal law, somebody commits a crime, you go to the court. Yeah, of course, there is a remedy. But 𝗟𝗵𝗪 𝗟𝗵𝗴𝗹 is the basis of law of torts in the world. Okay, Nikita. Okay, I hope Salus Populi Suprema Lex is clear to everyone. Moving on. Res ipsa liquidator. The next one. Res ipsa liquidator. What does the maxim res ipsa liquidator mean? Now suppose somebody, it's a very good illustration that is provided. Now suppose a clock tower which belongs to the municipal corporation collapse. 3 people die. Very, very important. A clock tower belonging to the municipal corporation collapses. 3 people die due to this accident or this incident that took place. The clock tower was 80-year-old. And normally the lifespan of a clock tower is 20 to 25 years. And during the course of inspection, it was found that the motor had lost its cementing power. Now, based on the principle of res ipsa liquitor, the municipal corporation is liable. The municipal corporation is liable. Am I clear? The municipal corporation will have to pay compensation to the family of those who died owing to that accident that took place owing to the collapse of the clock tower. Am I clear? All of you, am I clear? Is that clear? So, res ipsa liquitor happens to be that legal maxim which says that things that speaks for itself. Am I clear, everyone? Okay, moving on to the next one. The next one is nemo judex in causa sua. Nemo judex in causa sua. What does it mean? It simply means that no person should be punished twice for the same wrong that he has committed. Now, suppose a person has committed theft. Let me give you an example. Suppose a person has committed theft. Should he be punished twice? Should he be punished thrice? Or should he be punished once? The question over here is, if I commit a wrong, I should be punished once. एक इंसान ने एक बार चोरी किया, उसको एक बार पनिशमेंट मिलेगा. उसने 2 बार चोरी किया, 2 बार पनिशमेंट मिलेगा. 5 बार चोरी किया, 5 बार पनिशमेंट मिलेगा. But it cannot be that if a person commits one time theft, he is punished twice. Is that clear? Is that clear? So John is accused of robbing a bank. He is brought to trial. After presentation of all evidences, the jury finds him not guilty. He was tried and he was not found guilty. Can he be tried again? Can he be tried again? The answer is no, because he has been tried once. He was held not guilty. It was held that he is not guilty. So John cannot be tried again for the same robbery. But अगले बार, दूसरा बार अगर वो फिर से robbery करता है, court finds him guilty. He can be punished again. Is that clear? Is that clear, all of you? समझ में आ रहा है? Very simple. So these are very, very important. Yes, it's this is a principle of double jeopardy also, but double jeopardy is very, very important. Nobody should be jeopardized twice for the same offense. Okay, simple. Okay, that's very simple. I hope everyone is clear. Okay. Moving on to the next one. Impossibilium nulla obligation est. What does it mean? An impossible act you have no obligation to perform. Suppose somebody says, okay, I'll give you a simple example. Now, suppose I enter into a contract. I enter into a contract with Mr. A. There are two people, Mr. A and Mr. B. Forget it. Mr. A and Mr. B are two people who have entered into a contract. And what is a contract? They want to sell and buy 500 tons of wheat, gehu. Mr. A is from Ukraine and Mr. B is from Russia. They enter into that contract. All of a sudden, Russia invades Ukraine. There is a war, outbreak of a war, and Russia says that you cannot transact with a person from Ukraine. Ukraine says none of the people in Ukraine can transact with people in Russia. Is it possible for Mr. A to deliver goods to Mr. B? Is it possible? No. It is impossible now. Tomorrow somebody says, if you walk to the moon, if you walk from the earth to the moon, I will give you 100 crore rupees. It is impossible to perform. Can you walk to the moon? So there is no obligation to perform what is impossible. Let's see the illustration. Company A enters into a contract with company B for supply of 100 widgets or by a specific date. Company B agrees to pay the full price upon delivery. Before the delivery date, a fire breaks out in company A's warehouse, destroying all the widgets. Now, in this event, how will company A deliver the goods to company B? All the widgets are destroyed because of that fire. Am I clear? Can company B sue company A? No, because it is impossible for them to perform, for company A to perform. Is that clear, everyone? Okay. The contract will be void. Yes. These kind of, if you're talking about the Ukraine and the Russia example that I gave, yes, it is a void contract owing to the fact that, this kind of war broke out. Okay. Yeah. Did you understand the illustration? Okay. Brilliant. Let's move on. Let's move on to the next maxim. Delegatus non protest delegare. A delegated power cannot be further delegated. Thus, there are various laws made by the parliament which says that, we are making the act, we are making the law. The rules will be made by the secretary, parliamentary secretary. Can tomorrow the parliamentary secretary delegate or confer that power to someone else to create those rules? No. This is a very important law in itself. A delegated authority cannot further delegate its power to someone else. Company A hires John to represent and negotiate in a contract with company B. Company A explicitly grants John the authority to act on his behalf. Now, can John transfer his responsibility to George? No, John has been delegated the power to do something. He cannot further delegate. He cannot further delegate. Am I clear? This particular maxim, delegatus non protest delegare, restricts John from appointing someone else to negotiate on behalf of company A. Is that clear? Every one of you. Very simple. Very simple, guys. So guys, if you're liking this session, do press the like button, do share this session, because these are very important session that we are conducting. Okay, is that clear? So a person who has been given certain authority to do something, he cannot further delegate it to someone else. That is the law. Okay. Yes, Mohit. He says, but I don't understand only the. Okay. Okay. I'll come back. But he is just telling someone to do his work. No, he cannot. That is the law. He cannot tell someone else to do his work, because it is. See, he has been asked to do something. I have been asked to do something. Can I further delegate it to someone else? No. Okay. The next one is damnum sine injuria, damage without injury. Somebody suffers loss without violation of a legal right. Now, I'm sure that you must have heard about Gloucester Grammar School case, right? Where two schools were set up, and one was the older school, the other was a new school. Because of the new school being set up, the old school suffered huge financial loss because a number of students from the old school went to the new school. The court, the House of Lords, asked the old school that what is that legal right that has been violated by the new school? The old school says, I don't know, but I have suffered loss, financial loss, huge loss. The court said, I cannot do anything. Let's see the illustration. R&F Private Limited set up a new store selling clothes in a particular area. As a result, the neighboring store owned by Prakash, which also sells clothes, experienced significant decrease in customer and consequently suffered loss to its revenue. Although Prakash suffered huge loss, but there is no violation of his legal right. So can he claim compensation? The answer is no. He cannot claim compensation. He cannot claim compensation. And this is one of the very basic principles of law of torts again. Okay, very, very basic principle of law of torts again. All of you. Okay. Moving on. De minimis non curate lex. Law does not care about small little things or trifling acts. Now, I'll give you an example. Suppose you are traveling in a metro. It's बहुत भीड़ है metro में. दिल्ली metro अगर आप जाते हैं, it's jam packed. And now somebody pushes you. Can you tomorrow go to the court and say, Mr. A assaulted me, Mr. A committed battery on me? The judge will say, please go back home. These are small transgressions. We are not going to deal with all these small little things. Law is not concerned with trifling acts or small little transgressions. If a person uses a very short and inconsequential expert, something you have taken from somewhere, from a copyrighted work such as a few seconds of a song or a small proportion of a text, it may be considered de minimis. In such case, the law may not consider it necessary to take any legal action or impose any kind of penalty unless it causes substantial harm. Unless there is a substantial harm to the copyright owner. Am I clear, everyone? तो छोटा मोटा चीज के लिए, damnum sine injuria is related to law of contracts. No, damnum sine injuria is only related to law of torts. Because in law of contracts, we deal with terms and condition of a contract if there is a violation of those terms and condition. Okay, so let's not get ourselves confused between the two. Tulika. Next one. Actus non fecit rem nes menset rea. We often talk about the fact that crime consists of two important elements: your guilty mind and your guilty action. Unless there is both mens rea and actus rea, it is not considered as a crime. So, for example, a child below the age of 7 does not have mens rea. Can he commit a crime? The answer is no, because he does not have the intention of committing a crime. Am I clear? So an act does not make a person guilty unless there is a guilty mind. An accused who commits a motor vehicle accident leading to the death of a victim shall be charged for murder if the accused had the intention of killing. Otherwise, it would be considered as an accident or negligent on the part of the accused. Is that clear? Now, a person who is suffering from mental disorder cannot commit a crime because he does not know what he is doing. He does not have mens rea. He does not have the guilty mind. Is that clear, everyone? So guys, what if a child is trained? The Indian law says below 7 years, nothing is a crime. And if a child below 7 years is trained to do something, then the person who has trained him will go to jail. Not the child. Not the child. Okay. He will go for abatement. The next one. Necessitas publica major est quam privata. Public necessity is greater than private right. Now, suppose during the pandemic, the government says lockdown, the government says social distancing, the government says wear mask. Now, tomorrow you say, I have a fundamental right to travel within the territory of India. I have a right to speak. I have a right to travel anywhere. The government says nothing doing, stay at your home. The government may or can impose restriction on your movement because, public good is more important than your public, than your private right. Samajh mein aaya? You have a right to form association. 19(1) rights. You have a right to freedom of speech and expression. Government बोलता है कोई बात नहीं, mask पहनो. Social distancing, not more than 5 people together. Okay, you cannot come out. Now tomorrow you go to the court and you say that my fundamental rights are violated. Court will say that public good is more important. Public necessity is greater than your private right. Is that clear? Is that clear? Is that clear to everyone? Your liberties are important. Your fundamental rights, your liberties are important. But during that time, pandemic time, the court is also not going to look at it. A child below the age of 7 does not have any intention. That is what the law says. Okay. Okay. Is that clear? All of you. Okay. Brilliant. 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 So guys, before I say tata goodbye, there is a surprise for you coming soon exclusively on our YouTube channel. We are bringing to you 6 hours non-stop marathon for CLAT 2024, which will be exclusive in our YouTube channel, so do not miss it. In this marathon, which will be conducted by Abhimanyu sir, Nivedita ma'am, Alpa ma'am, Krishnendu sir and Ankur sir, it will be a 6-hour non-stop marathon coming soon exclusively on our YouTube channel. So guys, stay tuned for this 6-hour non-stop marathon. So guys, BYJU'S Exam Prep brings to you CLAT 2024 comprehensive course, wherein we are going to give you 300 plus recorded videos across 5 sections, 300 hours of live classes, 35 mock tests for CLAT and other law exam along with video solutions, monthly e-magazine for current affairs, and the entire content is based on our extensive analysis of the last 5 years of CLAT question paper. So guys, Do subscribe to our channel, and if you liked this session, do press the like button, share this with your friends so that others can also get help that we are providing to all of you. Do follow us on our Instagram, do like our Facebook page, do join our Telegram channel, and do not forget to download the BYJU'S exam prep app today itself. So guys, with this, we come to the end of this session. Thank you very, very much. God bless you. Yeah, we will definitely come up with a lot of illustrations in the next series also. Okay, we will come up with more illustrations. Don't worry, Garima. Okay, so guys, with this, bye-bye, good night, take care of yourself, stay home, stay safe, stay healthy. Bye-bye, good night, ta-da.